of the day too. All right, so our last presenter is Pam Goldman, and Pam Goldman earned her BSN and MPH and law degrees at the University of Minnesota, worked as a staff nurse at the University of Minnesota Hospital. She has worked as a health educator and a public health nurse, and during law school, she worked in the legal department at the University of Minnesota Hospital and worked in private practice and at the Minnesota Department of Health before joining Fairview's Risk Management Department in 2007. And I'll just say we really count on Pam's advice when we're developing our policies and procedures and whenever we have patient care issues that we really need help with. So I'll let Pam take it away.
Thanks. Can you hear me okay? All right, thank you. And okay, thank you for including me as part of this program today. And similar to the other presenters, as we're going along, if you have questions, comments, please just speak up. We don't have to be super formal. So my topic was to talk about holds. So you've already heard about mandatory reporting of perinatal substance exposure, and then you've heard, Dr. Jones's presentation on how you actually care for these patients and work with them in the clinical settings. And and I hope both of them will pop in with perspective and comments during my talk about holds. So we have 3 different kinds of holds that you can place on a patient in Minnesota. And I thought at the beginning I have objectives, 3 types of holds for each one. Okay, I don't know why this isn't showing this as the slideshow. Okay, good.
Should work. Oh my gosh.
Should we try broadcast slideshow? Oh, great.
Still not good. Yeah, now we can see the bottom.
Yeah, it's better.
Did I go back too far?
I think they're okay. All right, so let's try this. Yeah, so process, or when it's appropriate, how you put it on, who else might be involved, and resources to help get those things figured out. Quick overview of Fairview Risk Management, and I know many of you are trainees, so we have 3 risk management departments that support all of you. UMP, the University of Minnesota Physicians, is the practice group of our medical school attending physicians. And so the University of Minnesota, there's a lead attorney from the University of Minnesota General Counsel's Office who would be your direct resource, like if there's a lawsuit from a patient or if you get a subpoena to testify in court. You can always contact me and I can help you find that person if you don't have their phone number. Similarly with UMP, UMP actually manages many of the University of Minnesota hospital-based clinics. So Ruth Flynn or Nancy Lamo might be your first risk management resource for a patient care issue that comes up in one of those outpatient clinics. And then Fairview Risk Management, we own and manage the hospital. So we're kind of the front line for things that come up in the clinical environment within the hospital. And again, if it's like a concern about a potential lawsuit, we'll either make sure you want to connect with UMP or U of M Risk Management just to give them a heads up. But, or we can do that for you. So risk management, our department also encompasses workers' comp. So if you get a needle stick or some other kind of injury on the job, you want that to get reported. We have our survey readiness team who does mock surveys and helps respond when CMS is in-house, as they have been frequently lately. And then the risk management consulting, that's my job. There's 4 of us, and we support all Fairview hospitals, clinics, and different departments at the U of M. My assignment includes the whole U of M Children's Hospital and the birthplace and NICU. And we're just kind of the front day-to-day resource for things that come up, as well as working, like Becky mentioned, on policies and forms. We help with incident investigations. We help our licensed professionals respond to complaints, either from patients, or we help supplement what patient representatives and unit leadership are doing. And we can help you if you do get a complaint where you have to respond to your licensing board. And legal documents. So my topic is holds. Those are legal documents. Some of them patients are coming in from outside. And there are the temporary holds, and then there are longer term things like court orders for commitment. So if patients are coming in with those, we definitely want to have social work and risk management able to review those so that we understand exactly what they mean, and other issues that I'll be talking about, like who's the decision maker for the baby, or what are the limits on a patient's ability to choose. And claim, when I say claim in our context of risk management, we mean like that negligence lawsuit or other kinds of legal actions the patient can bring. That's a separate group that would be your point of contact if that, if a patient or family were bringing a claim against the hospital or the caregivers. So what I'll be talking about is more the proactive piece. Okay, so when we're talking about holds, I just wanted to back up a moment and say, well, why do we need a statute that tells us we can put a patient on a hold? Because patients have a basic right of self-determination. They can decide if they want to be here or not. They can accept or refuse the care you're recommending. And I don't know exactly what you learned in medical school or in your residency so far about basic consent for treatment and informed consent. I think most people really understand that patients have a right to consent under the, and then, if things are done to them that they don't agree with, in addition to malpractice and negligence, patients in Minnesota have a common law right to bring a claim in, it's another form of civil lawsuit that they could bring. Battery is an unconsented touching. So if you're doing something to a patient that's outside the scope of the consent they provided, a court would look at that and say, well, is that just a variant of medical negligence, or is that really like an unconsented touching that's not even it's an additional claim. False imprisonment, we even have a statute in Minnesota that makes it a crime to interfere with a parent's access and custody of their child. So if you're preventing a parent from having time with their infant or taking their infant home, you want to make sure you've done the right assessment and reasoning and have that documented in the chart to show that that was justified and that was important for that child's health and safety. And then there's federal law as well. There is something called a Section 1983 civil action for deprivation of rights that, parents sometimes sue doctors over restricting their own movement of leaving the hospital or restricting them from having access to their infant. Let's see, there we go. Okay, and then we have the Minnesota Bill of Rights, Patient Bill of Rights, that patients are given a copy of in some outpatient settings and on admission to the hospital, and where they have the right to get full information about their care and treatment options in terms and language they can understand. And refusal, they have the right to refuse care as long as they are a competent adult. So there can be a lot of, ethics things that come up, like what are the parameters when a patient is refusing care, or how do you make sure that, like, you're protected from a claim of negligence? If you advise a patient on a course of treatment, she refuses, and then later, either her infant is impaired or say she has a stillbirth. And, the concept that we teach is informed refusal. So it's all the same information you provide about, what the treatment options are, with a heavy emphasis on getting that teach back from the patient of what the risks are. And a patient who is a competent decision maker can refuse care that's life-saving or health-preserving for herself or even for her baby. Another issue that people, especially in OB, wonder about, as Dr. Jones said, who's my patient? We have a baby that's not born yet, and we want to maximize the likelihood of a healthy baby, but is that mom really able to refuse care that's important to make sure the baby has the best chance of a healthy life? Legally in Minnesota, she can. So, if a woman is having pregnancy complications and is at risk of losing her baby or having a stillbirth, if she refuses care, she does have the right to do that up until the time the baby is born. Any questions about that? No. And again, that would be addressed through documentation, plentiful documentation of what the risks and options that were she was told about in her understanding. So in the context of mental illness, chemical dependency, and exposure to prenatal substance use, there's 3 different holds that can be used to keep a patient in the hospital against their will. And these are the health and welfare custody of children that's placed by the police. Can I open this water? Then there's the emergency hospitalization hold, or often referred to as 72-hour hold. And I want to say there's a lot of confusion within our hospital, more so I think in our peds areas, about having 2 72-hour holds. And we all are very familiar with that term, 72-hour hold, and we don't always stop to ask ourselves, what kind of 72-hour hold are we talking about? And it leads to a lot of confusion. And then we've got the peace officer, health officer authority to detain a person against his or her will for assessment and or transport. I really apologize for the long title of that policy. I didn't write that. I'm more familiar from other institutions that I've worked at in the past with this being called the transport hold. And I think the people here at Fairview who worked on this policy tried to make the policy and titles match some of the language in the statutes. These second 2, emergency hospitalization hold and peace officer, health officer authority, come from a section in our state's Commitment Act. Okay. All right. So I'm going to start out by talking about health and welfare custody of children, since that's what the 2 previous presentations today were really focused on, is, when we report prenatal substance exposure to child protection may step in and say, for the safety of that baby and wanting to make sure that the mom doesn't try to remove the baby from the hospital before CPS has a chance to do their investigation, and before, medical and nursing providers and nurse midwives have a chance to finish their assessment and care of the baby, that hold will allow the hospital to keep the baby in the hospital for those 72 hours. So this hold can be requested by a nurse midwife, a physician, a nurse, or a social worker, but it is placed by law enforcement. So actually someone calls the police department or calls 911, a police officer may come up to the unit, and then the hold paperwork is either brought by the police officer or we have copies of it too. I think we have a Fairview form that can be filled out. And so a medical advanced practice nurse or social worker may fill out what the indications and reasoning are why we're asking for this hold to be placed. But then the police officer is the one that actually signs it, goes into the room, is responsible for giving a copy of it to the parent, and then a copy stays in the chart. And so I do want to just take a minute to read what that indication is, what the peace officer needs to have information or belief about. It's when a child is found in surroundings or conditions which endanger the child's health or welfare, or which such peace officer reasonably believes will endanger a child's health or welfare. So in other words, it can, in addition to perinatal substance use, this is also the hold that can be placed when an infant or child is in the hospital and the child needs ongoing care or treatment, and it's to prevent the parent from taking them out of the hospital against medical advice. And then it can also be placed out in the community, and the police can bring a child to our facilities saying, we found this child in an unsafe condition and are bringing them to you for a medical assessment of if they need hospital care or CPS needs to be involved, and child may end up in emergency foster care or a shelter or other placement. Okay, so we do have some resources to help sort out whether a health and welfare hold is needed with a baby that you're caring for. Center for Safe and Healthy Children has 24-hour availability. Social work is also on call 24 hours a day, and as is risk management. And obviously your attendings are reachable or in-house, I think, in a lot of cases. Let's see. I don't know why this isn't. Okay, and there is a form. For this one, for the health and welfare hold, as far as I know, we don't put an order in EPIC, but this form is either brought by the police officer or is available in Forms on Demand, and okay, sorry. But someone on the unit will be able to talk that through with you at the time if you're the one initiating this. Charge nurses are a great source of information, usually, and the social workers know this stuff very well. Okay, so what's kind of the process? Has anyone in this room ever been involved with placing one of these, besides Rebecca? Okay, Anne, here, you on the aisle here. Can you just give us a few highlights of what happened and what your involvement was? Okay, so someone who was on rotation had to come up, and there were safety concerns about, like, parents going home with the child. Is that it? Or just safety concerns of what was observed in the hospital? So they. Okay, so safety concerns with father being present. And so the social work was contacted, other notifications were made, a form was filled out, and a police officer did come and sign it. Okay, so it sounds like it went pretty smoothly. Yeah, you'd probably remember more details if it was traumatic. Anything anyone else wanted to say about how that process has worked or not worked? No. So, from a risk management perspective, I would just like to see documentation in the chart, the right form being used, and documentation in the chart from all members of the team. So, registered nurse midwife, or physician, social work, as to what the reasons were. And we would like to see in the chart documented, and the form itself will have the date and time it was placed. A couple other things that need to be attended to when that is placed. It's really helpful for the team to have a recommendation, if you have one, on whether contact is allowed or not, and to talk that through with the officer when they come, so that the box is either checked, yes, contact is allowed, or no, contact isn't allowed. And if you've already been talking to CPS before the health and welfare hold is placed, you may have their input on that as well. And if that box is checked or not checked, we follow that. But then that can be changed during the course of the hold if we get direction from Child Protective Services or the police. And then that would be typically documented in progress notes. So it's very important for the hold paperwork to be available in the chart. We can send a copy to HIM to help it get scanned in more quickly, but we always want to keep it available in the paper chart so that it's available for the care team. If contact is allowed, we keep an attendant with the family. So, and it's really more of a nursing decision, although providers may have input onto this as well, as far as availability of rooms and staffing, and just the, safety assessment of how that mom and family interacts with the baby. We want to promote bonding, and, it's going to be a process where CPS will be deciding if that baby is eventually going to go home with the parent or not. Even when babies are discharged to other relatives or to emergency foster care, the basic plan, and this is by statute, is there's a lengthy period where parents have the opportunity to try to establish good parenting skills and regain custody. So, what happens in those first days is very important for both the parent and the infant to maximize the potential for that eventual, either baby going home with the parent right away or eventual reunification. I did mention there about medical decision making. Normally, when a baby's on a health and welfare hold, the legal parents are still the decision makers for the baby and have the right to receive updates. There are a few rare situations where that might not be the case, abuse, or sometimes, like, the reason that a child is put on a hold is because parents are refusing or interfering with necessary care. So in those cases, the medical team might be providing care, on an emergency exception, and then working with CPS to get a court order saying who has custody. If CPS takes emergency custody, then someone at the county health department or the CPS caseworker may be the decision maker for the baby. Okay, and we do allow rooming in with an attendant while the baby's on a hold. Okay, so any comments or questions about that? Yeah, go ahead. Yeah, the question was if parents can consent to elective procedures for the baby when the baby's on a hold. Yes, unless we've gotten different direction from CPS. Yeah, so as was said in the earlier talks, communication amongst the healthcare team, this is really a team effort, and we're, whether like in a hospital like UMMC where we've got 24-hour access to maternal child social workers, I don't know if you do rotations at hospitals where you don't have that much support from social work and you're making some of these reports and doing more of this on your own, you might be the one actually talking to CPS and saying, are the parents still the decision maker, or is that going into county custody now? I mean, we do end up in situations in those early days sometimes where it really falls, by default, it falls to the medical team to be making decisions for a baby's care, with involvement of your attending physician, when you're in kind of a limbo where you're just giving updates to the parent, but you're not really looking to them as the decision makers. So that's why we also encourage you to make use of risk management or ethics, and both of those have 24-hour pagers. So 72 hours, what? And that is exclusive of weekends or legal holidays. So, okay, I am so glad you brought that up. So could everyone hear Ann? I'm going to try and succinctly repeat it for the recording. That was Ann Forrester Page, our lead nurse midwife here at UMMCH. She said she had a situation recently where an infant was, the team wanted to keep the baby in the hospital for observation for 72 hours after delivery. And somehow that was misheard or miscommunicated as the baby was on a 72-hour hold. And she went in and talked to the parents about, I just found out your baby's on a hold. And they were like, what? Yeah, and it created some angst and some confusion. So, great. I'm going to update. And one of the things, we don't have a lot yet. I mean, we have all the policies I'm talking about are searchable on the Fairview intranet, but and Rebecca and others have created some tools and flowcharts. So we want to have more tools and aids available for all of you and the nurses and social workers. So this concept of clarity around language is really crucial. So I'll keep going, but thank you for bringing that example up. So during that 72-hour period, a hold isn't just like put in place and it's like, oh, okay, we got the hold done. Now we just go worry about other things. It's like that. The beginning of the hold is the beginning of a 72-hour time frame during which other things happen. We already talked about the reporting to CPS. So during that 72 hours, for the child health and welfare hold, that is CPS's time frame to do their investigation. And then at the end of the 72 hours, before the end of the 72 hours, they should have communicated back whether there will be a court order for continued custody or whether the hold will be lifted and the baby can go home with the parents or, stay admitted longer if as medically necessary, but the parents will regain their rights to legal custody. And can you think of anything else we should say about that, Rebecca? No. Okay. Any other questions or comments right now about the child health and welfare hold? No. So, and we do, I think these are not uncommon in our NICU and in our birthplace. And as far as, from my perspective, it works pretty well because I don't get a lot of calls or concerns about this right now. And I think this, the NAS work groups that we've had have really increased people's comfort level with talking about it. I think changing the policy in the past, up until relatively recently, babies would always be in the newborn nursery and the mother could come in, to spend time with the baby. As we got this NAS work group going, we realized hey, that's not really beneficial for the NAS recovery process or for bonding. So that was changed, and I think it's been very well received and has worked well. So now I'm going to kind of briefly go through these two other kinds of holds that I mentioned, and then we'll have some time at the end for a couple case examples. So the emergency hospitalization hold is a whole different 72-hour hold that comes out of the state's Commitment Act, where the state will step in and interfere with a person's personal rights to self-determination when that person is a danger to self or others because of either mental illness, they're developmentally disabled. The term in the statute is actually mentally retarded, but we like to update that with some more current clinical terms, or chemically dependent. So those are the two things. They're a danger to self or others, which is linked to or caused by one of those three conditions. And the order of the court can't be obtained in time to prevent the anticipated injury. So kind of similar to the child health and welfare hold being that 72-hour period where CPS can go to court to get custody or do their investigation and conclude that they don't need to do that. Same thing is true here. There's going to be once the 72-hour hold starts, that's when the team needs to determine, are we going to we get pre-petition screening to come out, do their assessment, and work and decide if there's going to be a court hearing, which has to be before the end of that 72-hour period and either result in a commitment order or the hold being lifted with no commitment order. And so then the patient is either free to go or free to stay as a voluntary patient. So who can place this emergency hospitalization hold? The health and welfare hold, we all remember, is placed by the police on advice from a healthcare professional if we're asking for it. Emergency hospitalization hold has a shorter list. And again, certified nurse midwives have not been added into this statute yet. So it's licensed physician, licensed psychologist, an advanced practice registered nurse certified in mental health, or a physician assistant. So the good thing for the CNM is that you practice in a setting where you have hospitalists or OB or family practice doctors around that could step in and assess your patient, or very often you might be asking psychiatry to consult. and possibly be the one to place the hold if they deem it's necessary. So there's a form called the examiner's statement in support of emergency admission. And I think you get that from Forms on Demand. And I know that as a system, we're trying to work on getting more of this built into Epic right now. But I do know they're linked from the policies, and I think the resources that are available when you're working through this can help get access to the form once there's a realization that this might be needed. Very often, you might be talking with people like the advanced practice nurse for behavioral health or, again, psychiatry. And for the emergency hospitalization hold, there is an EPIC order that goes in the chart in addition to the form. And then there's two forms. There's one that gives the medical reasoning of why the hold is being initiated, why the person's a danger to themselves or others, either by reason of chemical dependency or mental illness or developmental delay. And that danger to self can include that the person isn't attending to their own needs for medical care. So if their chemical dependency or their mental illness is interfering with them getting other medical care that they need to preserve their life or health, that can be the basis or part of the basis for putting that hold. Very often it's also like homicidal ideation or suicidal ideation. And again, resources available to you to help figure out, well, is this patient even holdable? Psychiatry is not always available to come over and assess your patient immediately, but I hopefully, any comments about how available psychiatry is to consult with you on a curbside? Not as available as we would like. Yeah, okay. So, but if you want another talk just from them, invite them to come and speak. Yeah. Okay. Okay, and I already talked about commitment and how that 72-hour period is used to either have a order for commitment or release. So an emergency hospitalization hold can be removed by the same level of provider that placed it if they determine that the patient has improved and no longer meets that criteria of danger to self or others by reason of their chemical dependency or mental illness. And then we have the issue about substance exposure of the fetus during pregnancy and CPS involvement. So that can be another kind of commitment in addition to commitment for treatment, for mental illness. The county attorney would have to go to court to get a commitment, an order for commitment to chemical dependency treatment. I wish I could say more about this. Rebecca is nodding. Yeah, the commitment process is very complicated. Yeah, and Rebecca mentioned in her talk that up until 32 or 34 weeks, the county will not pursue commitment because of this issue of prenatal substance exposure. So I guess my comment about that is, if the reason you want to put the patient on a hold is because of the concern about the prenatal substance exposure to the fetus, is that a worthwhile reason to go through the added trauma to the patient of putting her on a hold? Or is it better to stay in the voluntary realm, the way Dr. Jones was talking about, talking with the patient about your shared goal of helping her protect her own health plus the health of her baby and letting her decide whether she's going to stay for voluntary treatment or not. So those are things as a risk manager I can't tell you. That's the kind of thing you can talk about in the medical and multidisciplinary care team. So I can tell you about the mechanics of the hold. It lasts for 72 hours for both, and exclusive of weekends and legal holidays. So if it's placed like at 6 p.m. on a Friday, you know, Saturday and Sunday won't count. So it'll expire Wednesday at 6 p.m. And we already talked about how it gets lifted or it expires. So one of the things we've seen is, like, if a emergency hospitalization hold is placed on a med-surg unit, and then you're trying to figure out, well, how do we get pre-petition screening? And, you know, well, we want to wait till the patient gets transferred to a behavioral unit, and then they'll work with pre-petition screening. It's important to do whatever you need to do to get those resources going, even though the patient's still in the med-surg or antepartum unit, because we can't put on a second 72-hour hold just because pre-petition screening hasn't been out yet. So the emergency hospitalization hold can be lifted if the patient decides that they're willing to be voluntary and accept care. A patient age 16 and 17 can voluntarily admit themselves to mental health or chemical dependency treatment. If they refuse, their parents can admit them. Then if they still refuse, they can be put on an emergency hospitalization hold. And we've also learned that the emergency hospitalization hold can actually apply to a patient to adolescents younger than 16. So, any other questions or comments about that emergency hospitalization hold? So now I want to talk briefly about something that we call the health officer authority or transport hold. So this is a hold that you can use in a variety of situations. A public health nurse I really struggled with my spelling here on sheriff. Sorry about that, I changed it so many times. So a public health nurse, a doctor in the community can place this and have the person transported to an emergency room for assessment. And again, this is the same criteria as the emergency hospitalization hold within the Commitment Act. So danger to self or others by reason of mental illness, chemical dependency, or intellectual impairment. And within the hospital, it can be used in a couple different ways. If you're in a hospital-based clinic or an off-site clinic and your patient is unstable and presenting that danger to self or others for those reasons, you can have them transported by security if you're in a hospital-based clinic, or by EMS to the emergency room. Yes, question. Physically resistant. Right. So that's the whole point of having these holds, is when a patient isn't agreeing to go get help. I mean, if your patient is extremely depressed, sobbing, and telling you they're suicidal, and you say, like, I think you really should get down to the emergency room and get you assessed there, and they say, okay, you don't need the hold. But when the patient is acting out, if you are in a hospital-based clinic anywhere on the UMMC campus, you can actually call a code 21, even if it's not within the hospital. If you're in, like, the Riverside Professional Building where the Women's Health Clinic is, hospital security will respond to a code 21, but they would like you to place this health officer authority on the patient as a legal basis for them to help transport the patient down to the emergency room. Did that answer your question? Yeah, okay. Right. So, exactly. That is a great example. So the situation was they were in a clinic across the street from the hospital. A patient became very agitated. They counseled the patient that it would be a good idea to go across the street to the emergency room for assessment and care. And the patient basically like ran out and ran down the street. So, and I would say not trying to physically restrain the patient yourself was a good choice. You know, just in the same way, if you've ever taken life-saving and they teach you, like, you don't want to drown along with the person you're trying to rescue. We don't want doctors, nurses, students, or anyone else being harmed. So if you don't have a trained team available to safely restrain a patient, then, you know, let them go. You know, notifying the police for a health and welfare check is a possibility. So I would say if that happens here during your residency, you know, you have resources available to say, here, my patient ran down the street, I'm worried about them, what are my next steps, if any? We can notify the police to go call on them and check on them at home. That's an option. So if it, and like I said, if it does happen on the UMMC campus, even in our clinics, security will respond. And this form, the Health Officer Authority form, is available, being linked from the policy or possibly Forms on Demand. And I'll try to find that out and communicate that back to you after this presentation so that you would know that. So that if you have the form filled out, calling 911 is an option when you're in, even in the hospital. We don't need the police to come in and help us too often, but we can, and certainly for our clinics. Sure. Okay, so the question was, does the health officer hold form have to be filled out before security or the police will restrain the person? I would say that's a little bit of a gray zone. I mean, if you're the doctor and you're saying this person is out of control and I need to put them on a hold and I'm filling it out now, I think they'll work with that because they want the person to be safe and to get the assessment and care they need. So the health officer authority is not part of this 72-hour confusion. It's even more confusing. It's indefinite. It's to get the person transported to the next place they're going. Sometimes the way it's used is like, say a patient is down at Southdale or Ridges or another community hospital and they're trying to send them to Riverside for either direct admission or further assessment in the ED. It stays in place until they get to that next inpatient unit or to the ED. So then the person has to be examined by the same kind of qualified examiner that can place the 72-hour hold. And then it's that qualified examiner that would determine if it gets lifted and they're now allowed to leave if they want to, or they can stay if they want to be voluntary, or initiate the emergency hospitalization hold. Okay, and again, the hold form needs to be in the chart. A copy can be sent to him for scanning into Epic. And we want to have notations in the chart of when it was placed, or if the patient arrived with it, we want to get it reviewed by social work and risk management so that we're clear on what kind of hold it was. And we want to have clear documentation in the chart from that qualified examiner who's saying either, now I'm putting on a 72-hour hold, or now I'm determining that this patient can be voluntary is free to leave or is free to stay for voluntary treatment if they agree to that. So I just wanted to mention a couple additional policies. Within the hospital, we can place an attendant or have other forms of supervision if we have patients who are on a hold. We have a patient search policy. Security can come up to the antepartum unit or the postpartum unit and work with the nurse or social worker or provider to search the patient's room if the patient is on a hold. And we don't expect nurses on antepartum or postpartum to do these searches alone, but that's why we have security available to come up and partner with you. And within that policy, there are situations where it's voluntary. The patient could consent to have their room searched. That is something that's highly recommended if you're suspecting illicit drug use during a hospital stay but don't have proof of it. Under our policy, we do call it a mandatory situation if you're putting a patient on a 72-hour hold and they have this history of substance use as the reason why they're on the hold. Okay, yeah. And then I wanted to mention Code Green. Is anyone familiar with Code Green? So are you all familiar with Code 21? Code 21 is like, you know, security comes and can take down the patient for you. Code Green is a few minutes before that, or maybe even a half hour before that. If you get warning signs that your patient is escalating and, you know, you're getting like those uneasy feelings, like this isn't going well, the Code Green will bring, I believe it's like a psychiatric nurse and possibly a psych tech to hopefully help de-escalate things, possibly make recommendations, either just behaviors, verbal de-escalation, possibly medications to try to calm that patient down, so to hopefully avoid the Code 21. And then threat assessment is a little huddle that we pull together when someone feels threatened. So when you have a patient that makes a statement of harming someone, you know, we want that to be reported and assessed. And here's just a quick list. You've heard a lot over this last couple of hours about these different resources that are available in the clinical setting, and many of these can be accessed through the charge nurse or through your provider colleagues and attendings. So I do have a couple case examples. And I think because we're about out of time, I already talked about this one. I don't know. Okay, why don't we just go for case example number 2 in the last 30 seconds here. Any thoughts about, you know, what your next steps would be right here? Is any kind of hold applicable in this situation potentially? Just throw it out. So if you're in the clinic and you're off-site, you would probably want to get this patient to an emergency room. So you'd consider putting on the emergency or the health officer authority and calling EMS to transport her to an emergency room, or having security come and walk her over to the emergency room if you're on the West Campus. And then as she starts yelling that she has a gun at home and wants to go get it, you know, it's like that's a good time also to be letting the clinic manager and know that there was a threat, and we can pull together the threat assessment huddle. So Yeah. Good question. So the question was, do you have to get the police involved? So we also have a state law and kind of a national standard of care around something called duty to warn. And that is if your patient makes a specific threat against an identifiable person, you need to notify that person. So if this patient had said, you know, my gun's at home and when I get out of here, I'm going to kill my next door neighbor because that's who's making me so upset, yes, you would have a duty to warn that next door neighbor. And we can either do that by tracking down, if we can find out, you know, if we can get the phone number, or otherwise we notify the police in the jurisdiction where that neighbor lives to notify them. So anyway, you have been a great audience. I appreciate the discussion and questions. I'll turn it back over to Becky.
All right. Thank you, everyone, for your attention during the afternoon. And I failed to introduce myself. My mother would wonder where the heck my manners are. Were you raised in a barn? And I can say, yeah, I was raised in a barn. My name is Becky Gams. I'm the Advanced Practice Nurse Leader here at the birthplace, and I'm one of those resources that you can call if you need help with anything. So please always give me a shout out. It could be for, you know, chemical dependency help. It could be for mental health. It could be, Becky, we've got a patient that needs multiple disciplinary care plan pulled together. So I'm kind of your go-to person to kind of help you pull that kind of stuff together. All right, thank you, and go enjoy the rest of the day.
Conference recording has started.
Shut it off. Hey. Oh, squad.
Where's the off button?
Hey. No, I just been asking that it goes up. Thank you. I said 30 seconds, just shut it down, and he said, I talked to her, she's going to review it and see. Yeah, that's fantastic.
That against the law.
Didn't you make those?
Sally designed.
Sally, because I knew somebody was making them.
Yeah, Sally designed.
Yeah.
Yeah.
So it's within our
Okay. Sure. This is for, you know, image, obviously a separate system, but
You have been disconnected from the meeting.